2016, like we did in 2015. We had the paid sick leave. That was really a lot of work for employers to change their handbook, change their policies, change their payroll, and apply to every employer. Fortunately, we don't have any laws like that in 2016 that really affect every employer across the board, and everybody's got to redo policies and handbooks. We do have a few laws coming out. For example, if you pay employees on a piece rate basis, that's going to pertain to those employers, and you're going to have to change how you calculate some of the pay for the piece rate. We'll talk about that briefly today too. But generally, for every employer, we don't have any major revisions. One good thing that I'll talk about here first is we actually got an amendment to this Private Attorney General's Act, the short term that we use in litigation is Paga, and it actually gives employers the right to cure certain violations, and this is some relief for employers. So we're actually starting off the presentation with some good news for employers going into 2016. But this law, and I'm getting a lot of feedback from clients and employers in California, think that this law is a lot broader than it really is. So we'll talk about how it's limited a little bit too. And just a quick Paga overview. Paga is also called the bounty hunter's law, and basically what Paga has done, it's a labor code section that the state passed because the labor commissioner and the enforcement agencies in the state of California were understaffed and under budget. They still are, and they just didn't have the ability to go enforce and collect these penalties that the labor code provides that they're entitled to go collect. So this state passed this law saying, look, we'll allow private plaintiffs and their lawyers to enforce these penalties that the state could only collect previously, as long as if they do recover penalties, 75% of those penalties have to go to the state, and they get to keep 25% of those penalties. That's why they call it the bounty hunter law. And these Paga claims we call them representative suits. They're different than class actions, but they're similar in that they can represent all of the employees that were affected by a policy. So it's still like a class action in that there's many people that can be involved. One person just has to step forward and they can represent everybody that was affected by a policy. But that's a little different than a class action in that they don't have to go through the class certification process, and they have different remedies and ways to prosecute the claims. And also, and I'll talk about this towards the end of the employment law update, we really have some good teeth built into class action waivers in arbitration agreements. Those have been enforceable, but California has said that employees can't waive their right to be a part of a Paga representative action. So these can't be waived by employees. And then also, before bringing a Paga claim, plaintiff's lawyer has to send a letter to the employer and the LWDA, a state enforcement agency, basically telling the LWDA that they intend to pursue this Paga claim, and it gives the LWDA a right to step in and try to collect those penalties themselves. Now, I've never seen it's been 10 years, I think, that Paga's been in place. I've never seen the LWDA say, we want to take the case on and collect those penalties ourselves. They always just let the plaintiff's lawyer do it. And but it's important, though, because now the employer, before they get sued or before this Paga claim comes down, and normally Paga's attached to a class action as well. But you'll get one of these Paga letters in the mail, usually certified mail, that is going to put you on notice that this is coming down the road. Now this law, the AB 1506, amended Paga to say, look, once you get that notice from the plaintiff's lawyer, you have the right to cure the certain issues that with these two issues, basically, that could lead to Paga penalties, and but you have to cure them within 33 days of receiving that notice. So it's really important for employers to pay attention if they get these notices to contact their attorney as fast as possible to see if they need to cure one of these two provisions. Now, the cure only applies to these two potential defects on a pay stub. It's the inclusive dates of the pay period and the name and address of the legal entity that is the employer. So it's not, if you have other problems with the pay stub that the employee is trying to pursue these PAGA remedies for, you don't have the right to cure those other issues. It's only these two issues, and that's where a lot of employers are thinking they can cure any violations they have on their pay stubs after the fact, but they can't. It's only these two issues, and I think it's important to keep that in mind. And so the law is already effective. It was signed into law. Law already took effect October 2nd, 2015. So effective now, employers have this right to cure these issues on the pay stub. Now, I get a lot of employers say, well, it's just a pay stub. How could the penalties be that much, these technical violations? But it's amazing how fast these penalties add up. It could be up to $250 per employee per pay period. So, if you have a couple hundred employees, these violations add up very fast, and it's something to pay attention to. And the pay stub is something everybody on the call should take a look at and review. And if you want us to take a look at it too, we'd gladly review that for everybody. And I've got a slide here listing all the information that needs to be on the pay stub to avoid these kind of penalties. Now, to cure the defects, here's some of the details on how to do that. It has to be done within 33 days. The employer also has to send a written notice by certified mail back to the aggrieved employee and the LWDA that the violation has been cured. And then the employer also has to go back and provide these fixed itemized wage statements, the pay stubs, to each employee going back 3 years. And you have to make your best effort to try to get everybody that's worked for you for the previous 3 years. So to cure, it's not easy to do, but it's a lot better to try to do this if you do have one of those problems with the if you haven't listed the pay period or the name and address of the employer on the pay stub. Now here on this slide is a pay stub and all of the required information that's on a pay stub. And I recommend that employers just sit down with their pay stub and make sure that each of these items is listed and get it as close as possible to what's on this slide. And I took this slide from a sample pay stub published by the Labor Commissioner as a model for what needs to be listed. And also now with the paid sick leave at the bottom of the slide, I list that you've got to provide how much sick leave is available to the employee as well. So that's another item that needs to be on the pay stub.